Today we're going to dive into the world of estate planning, and rather than just call it estate planning, because there's some connotations with estate planning that immediately people think it's just for something that occurs after you pass away, and I'm just going to rephrase it into something called your legacy. It's actually really important because you can actually cement something if you deliberately decide that I'm going to create a plan that's going to be implemented, and yes, it's going to be effective even when you're gone. But we're going to set up a plan that works while you're alive. But let's get down to it first. Number one, what's the thing that comes to your head when you hear the term estate planning? Just spend a couple seconds just thinking about, when I say estate planning, what do you immediately think of? And then what's your reaction to what you're thinking of? Because a lot of people think, oh man, it's when I pass away and then I got plenty of time, or they have a negative feeling that's associated with that. And so I want to replace that with, what do you think when I say creating your legacy? When you start thinking about passing your values on to the people you care about, whether it be family, organizations, maybe it's generational planning. But what do you think of? What kind of emotions do you feel there? Because that's actually really important. We want to tap into that. A lot of times when we're talking to clients, we're talking about creating 100-year, 200-year, 300-year plans. And it sounds immediately like, oh, that's only for the rich. No, it's not. Anybody can do it. And it's being deliberate about it that it really comes down to. And so I'm just going to go ahead and we're going to demystify some things. We're going to dive into the three types of options you have when we're dealing with estate planning. We're going to talk about really 4 ways that you can actually distribute your estate and kind of your options, and which plans allow which options, what things you need to do during your life, and then what are some of the pitfalls that we need to be aware of and plan around. And we'll do all of that within an hour. I promise you that this will be worth your time. If you spend some time here focusing in on creating a legacy, it's going to pay off, period. Let's jump into the myths first. And so I'm just going to kind of do a reality check on you. The number one reality check here is 100% of us are going to pass away. We can't take anything with us. In fact, this does not exist, right? You never see there's the U-Haul attached to the hearse and you're taking it with you. Can't take it with you. We are stewards of our wealth while we are here, and we can be stewards of our wealth when we are gone. If you are in the process of building wealth, you could still create a plan around that, so that if something happens to you, that there's still stewardship of that wealth, even if it's not completely created. And I'll just give you an example. A lot of you guys are just getting started, and you're thinking, but Toby, I don't have a big estate. In fact, I went in and talked to an attorney, and they were kind of looking at me funny, saying, estate planning's for the wealthy. Look, I'm going to equate this to if you called up an alarm company and said that you'd like an alarm system for your home, and they walked into your house and looked around and said, nah, alarm system's only for the rich. No, that is not the case, and they shouldn't be saying that, because it's as easy as this. If I have a body and I have a life and I know it's going to expire, I can insure it. I can create a plan, and even if I don't have the money for that plan yet, like maybe it's an education fund, maybe it's really important to me that future generations have the opportunity to get education because maybe it was denied you, or maybe you know how hard it was, and this is something that's important to you, you can create a plan, and even if you don't have the money, you can insure your life, and then if something happens to you prematurely before you build your wealth, it will dump that money in to implement your plan. You don't have to be a millionaire to do this. This is actually really easy. In fact, a lot of this stuff we're going to be talking about today has nothing to do with death. Has everything to do with while we are alive and making sure that we have advocates for us in the event we can't advocate for ourselves. So that's number one. We can't take it with us. We're all going to pass away someday, and we can create a plan, period. I don't care how wealthy you are, how poor you are, it does not matter. You can create a plan, period. Number two, there's a lot of idea that, takes money to make money. Money doesn't grow on trees, all these sayings. And the reality is, yeah, it does. About 5% of the wealthiest people who are millionaires, about 5% inherited it. 95% made it on their own. So can you. This is not something that's for just the elite. When you are talking about creating a legacy, it's like anything else. Anybody can do it, and it's all fair game. You just have to know the rules, and you have to know what tools are available to you so that you can implement things. In the world of investing, It might be taxes, asset protection, knowing how to preserve your wealth, making sure nobody can take it from you, minimizing your tax burdens, minimizing your risks. In the world of estate planning, it's about creating something that does not require a whole bunch of court intervention, does not require a bunch of depleted costs, and does not require that your estate be sold off. And we can deliberately set that up so that those things do not affect us. But I want to demystify that myth, that because most people have this idea that if you weren't born wealthy, you're not going to end up that way, and that's simply untrue. In fact, there was a national study. This is a book that was written by, I think it was Steve Hogan. Over 10,000 millionaires were interviewed in the top 3 professions were engineers, accountants, and school teachers for becoming millionaires, getting net worths over $1 million. What does that tell you? Nowhere on there was it movie actors being the top one or somebody who inherited money. It was regular folks just like you and me, and the fact that school teachers popped in there because that is not perceived as a super high earning profession. It's because they deliberately save. In most school districts, when somebody decides they're going to be a school teacher, they're saving for 30 years, and as a result, they retire with money. And anybody could do that too, but we're going to use some of those principles and apply them to building our legacy because the same rules apply. Here's an interesting one. 70% of rich families lose their wealth by the second generation. There's study after study that shows if you aren't passing on values that somebody can utilize and implement so that they can better themselves and better their financial position, that they are going to make mistakes with the money. In fact, over and over again, studies have shown that money can cause harm to people more than it does good if they are not prepared. So you do not want to create a situation where you're just dumping a bunch of capital onto somebody. Realistically, you want to create a framework for that money so it can continue to grow for the benefit of your descendants, for the organizations you care about, but that you're actually being very careful about it. In fact, there was a great study that was done at The Ohio State University. They studied windfalls, and they looked specifically at lottery winners, somebody who got a windfall, didn't earn it, right? They just got it out of the blue. And after a period of years, lottery winners kept only 16 cents on the dollar. 16 cents on the dollar. And after 4 and 5 years, studies have shown repeatedly that lottery winners have a higher propensity for bankruptcy than the rest of the population. So what does it mean? It means that people who do not know what to do with money, or are not prepared for it, or are the recipient of a windfall, more often than not will fail as a result. And we want to prevent that from happening. And estate planning allows us to do that, to where we are not just dumping money. Too many people have this idea of die and distribute. I'm going to die and pass everything on to my kids. You may be doing a massive disservice to them, and we'll show you some alternatives. So when you look at it, we've covered that 100% of us are going to pass, that we know that 5% of the wealth was inherited, 95% self-made, that money can cause harm, and the number 4, anyone can create an estate plan. Anyone. There's nothing that I just don't believe in this idea that somehow you have to have a certain amount of wealth. I do not care. You could be making $20,000 a year. You should still have the components of a good estate plan, which includes the power of attorneys for medical, power of attorneys for health care, living will provisions, documents for people so they understand what you cared about during your lifetime and what values you have that can be passed on. Especially if you have family members, you want to make sure to document this. Now, there are 3 choices that we have in the estate planning world. Unfortunately, there are people that pick number 1 quite often, and that is do nothing. Number 1 is do nothing. I'm actually going to write it up for you. So number 1 is do nothing. And what that means is I died without a plan, and that's called dying intestate. There are plenty of famous cases. Probably the biggest one was Prince, where they ended up going into the court. The state laws dictated who got the inheritance, and it ends up taking years and years to get rid of some of these estates. Some of them go on for more than a decade. That is not a cheap proceeding. It means that the estate is being dwindled down in legal fees and costs until there's nothing left. Now, there's going to be lawyers out there that say, oh, but if you have a small estate, it's actually really easy. But you're still defaulting underneath the state law. And depending on your family situation, this could have unintended consequences. Not to mention, this leads to causing people to disinherit their kids quite often. Because if you're doing nothing and you're falling under state law, quite often the recipient is a spouse. What if that spouse gets remarried? What if that spouse decides to do their own plan and disinherit your kids? You want to make sure that, by the way, if they get remarried and they pass away before their new spouse, everything goes to the new spouse and your kids get disinherited. So you got to make sure that you're not falling under this one, this do nothing intestate. Now, if you do nothing and go into intestate, you are going through a court proceeding called probate, which is a court proceeding for the orderly distribution of somebody's estate. Right? You're going to apply the state law where you reside and these assets are held. So if you have multiple properties, for example, real estate in multiple states, guess what you're doing in each one of those states? Well, I guess you're not doing it. Guess what your family or your heirs are doing in multiple states? If I have 3 states where I have real estate, I am probating in 3 different states. You got it. I may as well get an RV, call it the probate bus, and start driving around because I'm going to be spending quite a bit of time dealing with that. Now, probate can be expensive. There are numerous studies that have shown it's between 3 and 7% and sometimes as high as 20%. And I'll show you some of the statutes on this before some of you guys are out there are already getting revved up. I can see the lawyers. You're already like, I'll show you some of the statutes and you can see it. And there's been plenty of studies on this. I'll show you a really good paper on it as well where they did a deep dive, but I don't want to get ahead of myself. So doing nothing is intestate. Next choice is doing a will. You'll oftentimes see this being a cheapie that a lawyer says $199 and I'll draft you a will. That too requires probate. A will just says who is getting what in your estate. And again, it's going through this process. And this process of probate can take, on average, it's about 18 months. It depends on the size of the state and the state where you're at, but it can take quite a while. And the problem with probate, in my opinion, is you're requiring people to go into court. When you go into court, you quite often get lawyers, and lawyers are those folks that love to whisper in your ear saying, you're not being treated fairly, we need to assert your rights, we need to push, we need to make sure this, or maybe they take the position that they need to get you as much as humanly possible at the expense of your siblings, and that destroys families. So if you want to avoid that whole thing, then you have the option called a trust. Now, some of you guys are sophisticated and you're saying, Toby, it's not just do nothing, a will, or a trust. What if I have joint tenants with right of survivorship? And I'm going to say, yes, you could avoid this process by titling some things with joint tenants with right of survivorship, but a lot of the same issues, including the disinheritance that I'm talking about, could come up. You also have liabilities, so if you start doing this with kids, it's going to come up. And at the end of the day, somebody's going to have to do an estate plan for it because everybody's going to pass away. So you can't get away with just doing joint tenancy. It might work for the first spouse to pass away. Maybe you're doing this with the child. What if they get divorced? What if they get sued? They're starting to take your assets. Ignore all that. We still have to worry about what do they do with it if they end up getting it. We want to make sure that there's a framework for how our estate's going to be treated now and in the future. But a trust avoids probate. And now I'm going to say something else. A trust is private. Now, when you go into probate, that's a court proceeding. This is public, which means everybody can see what you have. There are actually cases where thieves targeted particular families, particular households, because in the probate, it showed that the kids were out of state and it had a listing of all the assets that were held inside the property, and they would go shopping, right? They'd go to the property, they know it's not occupied, they would break in and they would steal. You don't necessarily want all of your affairs in a public record. In fact, day in and day out, what Anderson does is we spend a lot of time making sure that our clients are out of the public record. We don't want you in the spotlight. We don't want to put a big old bullseye on you. If somebody thinks you have something, invariably they're going to try to take it away, and estate planning is no different. We'd rather keep your affairs private and avoid the courtroom. In fact, if you never go into a courtroom ever again, that's okay. If you never get to enjoy depositions or being a witness or going in and litigating and being a plaintiff or a defendant, that's okay. We don't actually want you to go to court, nor do we want your heirs to go to court, nor do we want any of the organizations that you care about, if you're leaving things to them, to have to go to court. We want to avoid that process, and guess what? A living trust, an inter vivos grantor trust, fully revocable, you can change it at any time, that will avoid probate. Assuming one big thing, that you actually put your assets in it. Now, some of you guys might be thinking, oh gosh, trust sounds complicated. It's not. They're fairly simple to set up. Well, what if I screw it up? We always have a backup plan. We never leave you just with the trust. You actually put a full plan in place, including a catch-all called a pour-over will. You end up with that will on any assets that you forget to put into that trust. But we don't want to have a bunch of assets outside of that trust. But if you have a car or an account or something, it's very easy to pick it up as a spare and put it back into that living trust. Do not worry. That is what good estate practitioners do. Now, here's why this is so important. I told you that I was going to pull up some state statutes and show you the cost. Here's an example. This is California. Average house is what, $600,000-$700,000. Let's just say that you have a car, a house, a retirement account, and you add it all up, and you're at $1 million. So how much would it cost? Well, it'd be 4% of that first $100,000. So we know it's $4,000. And by the way, this is attorney and executor probate fees, and it's the gross value of the estate. So we have 4% of that first $100,000 going to both the attorney and the executor, the person who gets to represent your estate. Isn't that crazy? So $8,000 of the first 1,000, 3% of the next 100,000. So that 3 times 2, 6%, which is another 6,000. And then we have 2% of the next 800,000. That brings us to $1 million. That 2% is 3,200, if my math is right, which means the probate fee for a simple estate, even if you have a mortgage, let's say that you have a $800,000 mortgage on this thing, you're still paying $17,200 for a typical probate. And of course, they can charge more if there's any other circumstances like contests. Here's another one. This is from a client that was in Pennsylvania. The father had passed away, and they wanted us to look to see, this is crazy. All he had was a home worth about $296,000, so about $300,000. And what was the fee? You can see that fee right down there. It was $13,500 for the cost of that. Just the attorney. We're not even talking the executor. We're not talking appraisals. We're not talking anything that we have to do to the court. We're not talking court fees. We're not talking any of that stuff. We're talking about just the fee to the lawyer, $13,500. They're going to sell that house. They're still going to pay a commission on it. They're still going to have to pay transfer taxes. They're still going to get hit with that lawyer's fee. They're still going to have to go to probate, so they're going to get hit with those costs. The client was actually the executor, so if they charge anything, it's coming out of their inheritance anyway. It's all going to be the same under that circumstance, but quite often it's one child and there's multiple children, or there's other heirs, and that can cause friction. But at the end of the day, it's going to cost them a lot to transfer a very simple asset that could have been avoided in its entirety by simply using a trust. Now, don't just take my word for it that it gets expensive. AARP did a study, and I remember when this came out, it was about 2002. And man, the Bar Association jumped down their throats. Estate planners were lambasting them and making all sorts of comments. And that is because when they did this study, they found that there was over $25 billion in costs to the lawyers in 1989 alone. And they went and they kept looking at that. They got it to $14 billion, and I think the last time it was over, I forget, it was over $50 billion a year is what the lawyers were making litigating these estates. So you tell me, it's a $50 billion industry. How are those lawyers going to react when you start saying, here's the way to avoid the lawyers? They went nuts. But what AARP found out was that it was between 5% and 10% of an estate was eaten up, and that the smaller estates suffer proportionately higher probate fees. In other words, it's a higher percentage for the smaller the estate. Goes on, this is the AARP study, and I gave you the site to the gentleman who wrote the article, but I remember the study itself. It's just gotten deep-sixed off the internet because the attorneys were attacking it so hard. But the AARP study itself estimated that it was 20% of the value to small to medium-sized estates. And if you have an uncomplicated larger estate, it was about 10%. So you just tell me, you sit there and you look at all the stuff you own and you say, do I want to force my heirs to pay 20% of those costs to some third party? I would say no. And there's a way to avoid it, and that is by using a living trust. So I am going to suggest to everybody that walks around, you're going to say, Toby, do you really think that everybody needs a living trust? The answer is yes. Everybody needs an estate plan, and a living trust is the best vehicle we have, period. Right? Now, maybe not, a 5-year-old child, right? But anybody that has a family, anybody that has heirs, anybody that has assets, absolutely, you need to make sure that you have an estate plan, period. And it's not just for when you pass away. I'll go over that in a second. But let's go to the ways that your estate can be distributed, because this will make it even clearer. Number one, you could just die and distribute, and that is called, let me change my color. Die and distribute means an outright distribution. I am just giving my asset away. So if I pass away, I'm leaving my house and my money, split it with my 3 kids, right? That's what you're doing. You're just getting rid of it. Now, that's where we start seeing issues, right? You're starting to dump assets onto somebody as a windfall, and we already know what the ramification of that. It's not going to be pleasant, right? Or you could be distributing assets to somebody that has a substance abuse issues, is in the middle of a lawsuit, maybe they're going through a divorce, whatever. You do not know the circumstances in which you're just distributing this. So the other thing you could do is say, hey, you know what? I don't know, so maybe I'm going to distribute over a period of years. I don't want to just dump everything on them, so maybe it's 30% year 1, 20% year 2, 20% year 3, 30% year 4, whatever, right? You're distributing it over a period of years, and you're keeping the estate tied up for a while. If this was a will, you'd have a bit of an issue. You're going to have this going for a while. You really need to have what's called a testamentary trust at that point that gets created, which defeats the purpose of doing the will in the first place. Just do the trust, right? Why have a will create a trust? It doesn't make sense. Just do the trust and say, here's what we're going to do. Now, there's a reason why you do the trust, because there's provisions that allow a trustee to withhold the funds if the party is incompetent or incapacitated. Let's say that you have somebody that's an heir that has special needs. You don't want the state to just take the monies that you're giving them, because that's what they will do. There are cases on the book where people who had the estate taking care of them, there was one child who was autistic, and the state supported and helped that child. The grandparents thought they were doing a good thing and left the child money, and the state stepped in and said, here's 18 years of payback. The child was now an adult, but they were still entitled to reimbursement, and because the money went to the child and there was no credit shelter provisions, there was no special needs provisions, they were able to take that inheritance, and that's what a trust will do for you. It protects the heir not just from themselves. If they have substance abuse issues, the trustee can withhold it. If they're being sued, the trustee can withhold the monies if a creditor is trying to attach it. That's called a credit shelter provision. There's all these different protections built in, but it'll protect the estate from third parties as much as it'll protect it against the heir themselves. And in all cases, it's for the benefit of your legacy. And that's why it's important to actually have those types of provisions. Other things you could do is you could do it at ages. So for example, if you're worried that you have heirs and maybe you have kids and they're young and you're worried, boy, you know, I was a knucklehead until I was 25. So you could say, hey, what do they get before they're 25? What if I put provisions in here that restrict their ability to get the money? Are they just left out in the cold? No, you can leave instructions. We call it health, education, maintenance, and support, or HEM standards, where you're saying to a trustee, third party, and this could be a relative, this could be a fiduciary, this could be a lawyer, an accountant, it could be a trust company, it could be a bank, whatever. You could say, give them money if they need it for health, education, maintenance, or support. In other words, if they're going to go through school, you could pay for their school. If they need a car, don't get them a Rolls Royce, get them a reasonable, maybe they're getting a Camry. They will never be homeless. There's money there to make sure that they have maintenance and support, but they can't take the money and buy a Lamborghini. They can't take the money and go do something dumb with it, right? So it's protected from themselves. So even before they reach the age, so let's say that you said, we want to do age 25, 35, and 45, and we're just going to do 1/3, 1/3, 1/3. You could do that. And if something occurred during those periods of time, they just wouldn't be able to go take the estate. It's sitting in there growing, but they're not out in the cold if they need the money. If there's monies that they need, they can actually say, hey, I need this, and again, for HEM standards. Or you could create other things, like, hey, if they want to do a mission, you could fund that. If they want to travel the world, you could fund that. If you said, hey, it's really important that you get out of the country, I will fund 7 to 14 days in a different country that you've never been to before, you know, and my trustee should make sure that it's not just frivolous, that they're going to actually travel there and can provide reasonable sums for them to do so. And you could do that. Hey, here I want my beneficiaries to actually go out and travel around. How many of you would have liked to have been a beneficiary under a estate plan that said, I want you to go to a different country every year? Yeah, and what would you be thinking? If that was your great-grandparent, you'd probably be going, man, they must have really liked to travel. And wow, that is really cool. They've really blessed me, right? And you're probably going to want to know a little bit something about them, right? All of a sudden, there's some values being passed down. It's not just money. There's values being passed down because you can actually direct some of it. Or if you were a recipient of an educational trust, where, you know, grandparents set up a trust so all the kids could go to school, all the grandkids could go to school, you're going to remember that grandparent. And you might want to know something about them, like what made them tick? Why was this a big deal? Oh, they had to really struggle to get through school, or they were denied the opportunity. I had a grandparent, they had to leave school in 5th grade to go work, right? And that was a big thing when my dad went to school. He was the first one on that side of the family to ever go to college, and that was a huge thing for them. Well, I still remember that, but is my daughter or her kids going to remember all that? If I put something into writing and I say, here's the reason that we're doing this, we can start passing that down, and you're starting to create a legacy. I can even borrow that from my grandparents. I could say, hey, you know, my grandparents, who might be your great-great-grandparents or your great-great-great-grandparents, they really had to struggle. They had to leave school in 5th grade to go work and support the family. As a result, I'm creating this educational trust for the benefit of all of our descendants so that they can go to school. Yeah, that's passing down a value, and it's creating a legacy for that family, and it's making it very clear. People understand that. That's a big one. So you could do this at ages. The other thing you could do is do it at accomplishments. For example, hey, you get money when you graduate from school. You could put a target. You could even put a dollar amount. Hey, if you get a 4-year degree, then it's $10,000 adjusted for inflation. so that it continues to go up, so that in 100 years they're not looking at you like you're funny. Like, hey, you almost paid for a week of school. It was $10,000. Who knows what inflation's going to do, right? So it could actually be accomplishments. It could be doing something like, hey, when you get your fifth investment property, then here's some money. Like, you've shown that you have the ability to be an entrepreneur, an investor, and you're growing it. Or it could be a matching. Hey, there's money here if you know to do half of your down payment, things like that. So you could do at ages or accomplishments. So I'm going to call this 1, 2. I would call these 3, and then 4. In 4 is really creating a dynasty where you are just doing hem standard, and that's it. Maybe some specific items where, for example, the travel, you could always throw that in there, or if you wanted someone to do mission work, or if you wanted someone to do volunteer work, or things like that. But it's really having no distribution. Like the heirs can't come up and say, give me a third of the estate. So if you have $1 million estate, they can't walk up and say, give me $333,000, and a trustee has to hand it to them, right? We here, the money stays in the estate. We set these up to be 365 years here in Nevada, so that, and if it has to go longer, there's ways to do that, to extend it out by decanting into another trust and things of that nature. But we start off going, hey, this is going to be many generations. That's about 10 generations, by the way. And so you're looking at it going, we want an estate that's going to continue to grow. And before you look at me like I'm completely Looney Tunes, understand that there are plenty of families that started their legacies a long time ago, and they're continuing to grow because it's not being depleted. It continues to be invested. It continues to grow. In many cases, you have a professional trustee. For example, Vanguard does this. If it's over $1 million, they'll do all the accounting and everything on that trust. I think it's 0.5% a year, and they invest it. Like, good luck finding someone to handle and professionally manage your money for 0.5% a year, right? It's actually a great deal. And if you let them do that for 50, 60, 70, 100 years, 150 years, you're going to see if people, like if you have great kids, great grandkids, great grandkids, right? And they're not just depleting the estate because they have needs that are excessive, the estate could continue to grow year after year as it's continued to be reinvested. And it can really create something special for your family. And that's why I say legacy. Now, before we dive too deep into that legacy, let's talk about the different sections that we need to worry about when we're talking about your estate plan. Because it's not just about passing. In fact, this is where that upon passing is, it's about halfway through your estate, right? We really need to cover things that will handle matters during our lifetime. So if I broke this into three sections, I would say, during your lifetime, what kind of documents do you need? Upon your passing, what type of documents? And then after your passing. And just know that the will only lives here. It's only there after you pass. It's 1/3 of the estate plan. Yet many people mistakenly think, I did a will, I'm done. It doesn't work that way. During your lifetime, there are situations where you may need an advocate. You may be incapacitated. You may get, as you get older, we all get older. My dad had Alzheimer's for 7 years, so he needed someone to handle his financial affairs. He needed somebody to advocate for him on the medical front, which is a power of attorney for medical. During COVID, we saw this over and over and over again, where if people didn't have advocates, the default wasn't necessarily in their best interest. In fact, if you remember, the do not resuscitate order that was standard in hospitals, you had to have a power of attorney to overcome that, to say, no, I'm going to push back. I want measures taken to preserve life. You needed to have that advocate. If you didn't, you were in trouble. And that's over and over again. Let's say that you are a couple and you're unmarried and something happens to one of the spouses. I will give you a real life situation. One of our attorneys was getting married. They were, I think, 3 weeks out from being married. Her fiance had a car accident and ended up in ICU. She went to visit him and she was denied access because she wasn't family. He ended up passing away. How does that feel, right? You want to be able to see that individual. And it put her on a path of wanting to be a crusader for making sure people had the appropriate documents so that they did not have that same situation. Or let's say that you are in a relationship with somebody, your family doesn't like that person, and you're unmarried. And you end up in, that person ends up in a situation where they're in the hospital or they're sick. And for whatever reason, that family just says, you're not family, you're denied access. You have no recourse. You do not get to come in and see that individual. And especially if it's life-threatening situations, that can be a very painful experience. And so I really would suggest everybody have a medical power of attorney where you're designating who could act on my behalf. This may be a different person than your financial. Like maybe you have kids and you're like, one of them's a nurse or one of them's a doctor and they get this stuff. I want that as my medical power of attorney. One of them's a CPA or a planner. They're handling the finances. You're designated, or it's your spouse. But you're picking somebody to advocate for you in the event that you cannot. And I'm not talking about end of life. I'm talking about during your life. You go in for surgery. Anything goes wrong, you want to make sure that you have somebody designated. Or I'll give another real life situation. I had a client and her son in his 20s ended up contracting a brain virus, like a fungus, it was a fungus. He had inhaled it while he was treasure hunting in a foreign country, and his brain swelled up. Wasn't able to get on a plane, ended up being in a medically induced coma for about 6 months. During that period of time, multiple foreclosures, all sorts of issues with his business, all sorts of issues personally, because nobody had the right to contact and access and talk to those creditors. If he had had a power of attorney, mom could have gone in, said, here's the medical document that says son is incapacitated, and I want to see the account, and I want to see who what bills we're supposed to be paying. You could start reverse engineering. You could start talking to creditors. You could find out who you've been paying and what are the bills, make sure nothing goes default. Because when he came back to the United States, he was in a foreign country when he contracted the fungus, he was virtually into bankruptcy. And it was a big mess, and it affected him for many, many years. Easy fix would have been to have the estate plan. But everybody thinks, I'm young, I'm indestructible, it's not going to happen. The end of life is where you end up using something called a living will. And that is, do I want extraordinary measures taken or do I want my plug pulled? A lot of people immediately think, I don't want to be kept on life support. I don't want that. I get it. But you want to have somebody communicating with the doctor, and you want to make sure your wishes are maintained. You don't want them just to pull the plug if you have artificial nutrition, because that could be a lot of different scenarios where your life's not in jeopardy, and all of a sudden now you're putting yourself in a really precarious position because it's written there. You want to have somebody who's communicating with a doctor on your behalf, and you have written, like, here's what I want. Here's whether, this is the level of care that I want. I had a client who I represented as a power of attorney. I was actually her court-appointed guardian, and she wanted extraordinary measures. She was an indigent person. She didn't have a lot of money, and she was convinced that they would prematurely pull that plug. And I got to tell you, in 11 years that I represented her, 3 times there was situations where the recommendation was to discontinue life-saving care. And I had that document, and I said, I cannot authorize it, just kind of made it a moot point. And it just, the way it was, she ended up recovering in all 3 situations and living a very long life and passing away of natural causes in her sleep. It was one of those things, and I'm not saying anything negative against the medical community. They're basing it off the best that they can. But if you are one of those individuals that says, I want extraordinary measures, put it in writing. Because a lot of folks are saying, hey, knowing what I know and quality of life and based off of my experiences, this is my best advice to you. You want to be able to ask questions. You don't want to just have somebody decide, no, it's time to discontinue life. And that is something that occurs on passing. Again, a will does not do it. It's called a living will, but it's not the same thing. It is literally a document where you document out who gets to make that decision for you on your behalf. And quite often, most states have an election where you're initialing what you want. Do I want extraordinary? Do I want to let my power of attorney decide? Do I want to have somebody talking to my doctor? Or do I want extraordinary measures taken, period? And so you can start seeing when we lay these things out, we've only gotten to here thus far. We have a power of attorney for financial, power of attorney for healthcare. We have a living will. And now, finally, we get to that end of after passing, we have a will. Here's the rub. That living trust starts to work the day you sign it. It can be used immediately, depending on whether you're incapacitated and you want to use a trustee. It could be used when I pass, but it works that entire timeline, and then it continues to work after I pass away. So you have that will versus a living trust. It's quite often what people are comparing, and it's a false choice because the will is nothing like a living trust. The will is effective only under one circumstance, and that's when you pass away. And a lot can happen during your lifetime before you pass away. Once you have passed away, a will distributes. It does not hold, it does not do estate planning, it does not allow you to create a legacy. A living trust allows you to create a legacy. And that's what I would suggest that you do. Now, what other factors are there? Well, here's the reality. There's a lot of messes created because of the type of estate planning people do. A lot of folks, and my family was victimized on a few of these. So like I have personal experience. They go into the estate planner and they say, I need an estate plan and I want to make sure it's covered. They draft you a will, they send you home. And then you end up with a relative who's in the hospital and there's decisions that have to be made while they're incapacitated, and there's not people that are elected to make those decisions. So they end up talking to maybe a spouse, but they're trying to do the best that they can for that person without the input of an advocate. And I would suggest that you make sure that you always have an advocate seeking that input, and that could make a mess. And I don't care whether it's nursing homes or anything that you're dealing with, you want to make sure that you have documents, because otherwise you end up with a big mess. And that's where I'm always looking at those truths. We're all going to pass away. We all have issues before we pass away, and we all want to make sure that we're not harming somebody after we are gone. And those things are handled through a proper estate plan. Now, if you do not do a proper estate plan, then you get the beauty of some of these messes. And I'm just going to use this cheap Tweety Bird figurine. This was actually an article that was written, but it's based on a case that a gentleman litigated down in Georgia. And what it was mom passed away. Mom had a plastic Tweety Bird in her kitchen for 40 years. That Tweety Bird was worth $1.50, according to what they could find on eBay, because the attorney found a identical Tweety Bird for $1.50 and said to the two siblings who were fighting over the Tweety Bird, let's just buy this, we'll put it in a box, shake it up, you each take one, nobody knows the real, nobody knows the fake, and you go about your merry way. And they said no. They wanted to litigate. You end up inviting issues. So when you go to probate, I'm just going to say it, if you don't have a mechanism to prevent it, you're going to end up with people who are on their worst day making their worst decisions. And it's emotional, there's grief, there's money, there's fear. Quite often there's influence taking place, and people end up making allegations against each other and harming their relationship, which nobody wants in their family. And the way out of that is having a document that says, if you contest, you're disinherited. And that's what we do in our estate plans. If you contest, you are going to have consequences. So think very strong and hard, very long and hard about your decisions. Otherwise, we're leaving it to the trustee, period, in how they want to distribute it. Now, an easy way around this is to do a schedule of gifts, and if you have sentimental items, make sure that it's easy to determine who's supposed to get what. Don't just say, they'll figure it out, they'll divide things up, because that creates fights. I remember there was one motion in one probate action. It was $5,000 of attorney's fees for one side over Christmas plates. So, just imagine they spent over $10,000 in attorney's fees fighting over Christmas plates, that an adult's going to say, here's a mechanism, let's start to barter. But the kids were absolutely at each other. Here's another way to look at this. If you want to have a probate dispute, if you want to make sure that your kids fight, what you do is you have your siblings, you have, let's just say, mom, and let's say that one sibling takes care of mom. Oops. As mom gets older, that sibling is the one that lives nearby or lives with mom and takes care of mom. Mom decides to give more to that sibling. In her will. Mom passes. Big fight. Why? Undue influence is what they're going to say. You were taking care of mom and you told her to give you more. Maybe mom says there's 3 siblings. Maybe mom says half of my estate. Like, I really appreciate you spending the last years of my life caring for me. And I know you gave up and had sacrifices, so I'm going to leave you extra money. Maybe it's 50%, and then the remaining siblings are going to get 25. That's a recipe for a lawsuit. That is going to be a contest all day long, because the other siblings are going to feel guilty that they weren't helping, or they're going to think you did something else, like the sibling that took care of mom. Oh, you stole money. This is something that happened in my family, so I could tell you that I know what happens. They don't talk to each other anymore on that side. It was my wife's family. And the brothers and sisters ended up fighting for years. They do not get together anymore because there was a belief that somebody took advantage of grandma before she passed. I've seen it over and over again. My partner Clint, he had the same thing, a very similar situation where somebody was taking advantage of his grandma. He wasn't able to see her for years and years and years and years. Caused a big division in the family. There's a way away from this, and that is to make sure that there's a third party involved and that there's a ramification if they decide to dispute. In wills, unfortunately, it's a grease slide into disputes and into litigation. It actually encourages it because you're supposed to make, hey, if you have any contests, then you could do that. Another thing people do with their estate plan unintentionally, but again, this has happened on my mom's side of the family. It's like, again, I'm living a lot of these things, guys. A lot of you guys have lived it too, because these are fairly common. If you want to make sure that you disinherit your kids, you do, number one, make sure that you have no estate plan. Make sure that you have either a simple will or you're defaulting under state law. Step 2 is pass away. Your surviving spouse will inherit everything. Step 3, surviving spouse remarries and passes away before their new spouse. And I just say repeats 1 through 2. So this is how it works. Let's say it's John and Sally, and John passes away before Sally. Sally remarries. Let's say John and Sally have 3 kids. Sally, she's distraught. After a few years, she recovers and gets remarried. And she remarries a younger man, maybe, or could be older, doesn't matter. But she ends up passing away before her new husband. What happened to the kids' inheritance? Now everything goes to the new husband. Now this happened in my mom's side of the family, and I could tell you what they did when we came a knocking. My mom and her sister said, these were a lot of our family heirlooms. It's my grandparents who had come over from overseas, and there was lots of things for the family. And the kids said, there's an estate sale. You can buy anything you want. And of course, they were very upset. It wasn't a huge estate, but there was sentimental items. We're talking about diaries, some firearms that were antiques, things like that. You do not want to put yourself in a situation where you unintentionally disinherit a family. And even more importantly, that you don't disinherit your kids, which would happen under those circumstances. And the easy way around that is with a trust. You can do what's called a Q-tip provision, which means first spouse passes away, their estate gets locked down for the benefit of the surviving spouse. Surviving spouse uses their half of the estate. When I say the surviving spouse's half of the estate to live. If they need more capital, if they need more money, then they can use the portion of the estate that from the first spouse to pass away. But what's really important is that they can't change it. When they are gone, when the spouse is gone, who gets that estate? It would be whatever you put into your document. So it could be that it's going to your kids. Maybe it's just going to go in, you're creating a legacy trust and it's going to be held for your descendants. Then it doesn't matter what the surviving spouse does. If they get remarried, if they disinherit the kids themselves with their half, they can't make that decision for your half, and it will go to those kids. It'll make sure that they do not get disinherited. And if you think I'm crazy, there's plenty of cases out there. You all have heard of Anna Nicole Smith, of older gentlemen. They live longer than their wives, and they end up making a little bit of a bad decision. Like in the case of Anna Nicole Smith, I think the gentleman was 88 years old in a wheelchair, and he marries a playmate who's 28 years old. He's worth billions of dollars, and then of course he predeceases Anna Nicole, and ends up with a huge mess. I do not think his wife would have said, hey, if I go, what I really like you to do is to marry a younger Playboy model and disinherit our children. That would make me so happy, right? I don't think that's what was going through her head. And a simple estate plan with these types of provisions that it would have prevented this from occurring. And just so you don't think that I'm sexist, it works both ways. Mom survives husband. Mom, what if she marries the pool boy? Or in this, yeah, I'm not sure if he was the pool boy in that one. But, and mom makes a poor decision in the future. You want to make sure that you're not disinheriting your kids under that circumstances, or that you're not disinheriting your legacy, depending on who you're trying to benefit. It could be organizations, it could be your kids, it could be family, it's descendants, it could be people that you care about. You want to make sure that by not addressing it, that you don't unintentionally cause it to be destroyed. In a living trust, we can address it. And I'm going to give you one last statement here. And this is through our friend Steve Harvey. And I want you to listen to this. It had an impact on me, and I'm going to see if it has an impact on you.
I was with a friend who went to the hospital one day, and asked me to go with him. His grandmother was dying. He said, hey, Harv, you know you good with this kind of stuff, just go with me, man. And I was just standing behind him, just sort of holding him up, man. Come on, man, just stay on your feet. He kept calling, my dear, I love you. And she said, baby, I'm not gonna make it. I'm finna go home. But I called you down here because I want to ask you something. She said, do you know your great-grandfather's name? He said, no, my dear, I don't. She said, you know why? She said, because he didn't leave you nothing. She said, when I die, I want you to go away from here, and I want you to live your life so that your children's grandchildren will know your name. And the only way for them to know who you are is you got to leave them something. That day, he didn't get the message, but I heard it though. I heard it. And when I heard that, it changed me. And it changed me to the point where I said, wow, I'm gonna start living my life so that my grandkids' kids know my name, then I've accomplished the deal.
pretty potent, right? When you start thinking about it and you start saying, can I create a legacy? Then it's really simple. I have a very simple directive for you. First off, yeah, you can. And we started off with the slide where I said estate planning has a little bit of a negative connotation. So I said I'd rather have your legacy. I'm just going to add one thing. It's actually really simple. And if somebody's told you that you can't, I want to assure you that they're lying. You can. And to make it even easier, I'm going to include with this video a link, and it's going to get you started absolutely free with an emergency binder so you can start your estate plan and you don't have the excuse of it's only for the rich and it's too expensive, because you can start documenting your estate and your wishes right away. Simple things that we all need to do. Who are my friends? Who are my doctors? Who's my dentist? If I have kids, who are their friends? Who takes care of them? What kind of activities do they do? How do I pay my bills? If you're military and you served, first off, thank you. And second off, that we know that benefits have a timeline where they have revolving passwords and things like that. You want to make sure somebody knows how to access your accounts. And we have a binder that allows you to leave that information securely with a separate password list that's not with the binder. So if somebody finds your binder, they cannot access your information. But for a loved one, they would know the mechanism to absolutely start to act on your behalf. And I'm going to leave that to you absolutely free so that you get started. But I'm going to ask you something. I'm going to say, I'll give this to you, but you got to make me 2 commitments. The first commitment is that you implement it for yourself. The second commitment is that you share it with people who you believe would benefit from actually putting things in writing and making sure that they're not leaving things to chance and they're not leaving their heirs in a lurch if something happens. Now, the emergency binder is not a living trust. It is the start of a good estate plan. The next step would be if you implement that estate plan itself, the living trust itself, and I invite you to do it. But this is the important step. Make a commitment to start your legacy.